Hello everyone, welcome to our channel. This is a Posh at Work presentation of legal insights on important issues surrounding sexual harassment and related matters. Posh at Work is a boutique firm which assists organizations across sectors in complying with the law against sexual harassment at workplace and related matters pan-India. My name is Sania Talwar. The judgment I will be discussing with you today is in continuation with our previous video, which is Jaya Kodate versus Rashtrasant Tuktoji Maharaj, Nagpur University by the High Court of Bombay, Nagpur bench, decided on June 13, 2014. As recap, this judgment clarifies interpretation of several basic and very important provisions under law that form the basis of understanding applicability of this law. As we discussed last time, this judgment throws light on the following questions. Whether the law deals with sexual harassment of employed women only. Who is an employee under law and who is an employer under law? In case respondent is an employer but also has ingredients of employee, whether the local committee will inquire into such complaints or the internal committee of a workplace will do so. What is a workplace and how are internal committees required to be constituted? What should be the composition of internal committees and what should they look like? What is the role of members and the independent external member? How do internal committees work and how are reports required to be prepared? So that we are able to understand the judgment of this court on each point in its entirety, we divided this discussion in three parts. We discussed the judgment of the court on the first three questions in part 1. In this part 2, I will cover question number 4 and in part 3, I will cover question number 5 and 6. As quick recap, in this case, 3 writ petitions were filed and the Bombay High Court decided to hear them together as all these petitions raise identical challenges. Some of the other relevant facts in this case to give further context to question 4 are: A. The petitioners who complained about sexual harassment were employees of senior college. B. Respondents were related to a senior college and a junior college. C. The internal committee that was constituted at the senior college to inquire into complaints of the 3 petitioners consisted of one committee member by the name of Srimati Brahmkar, who was an employee of junior college. In the background of these facts, the petitioners contended before the court that sexual harassment is in relation to workplace, which is senior college and not a junior college. Srimati Brahmkar happens to be an employee of a junior college and therefore not connected with the workplace in question, that is senior college. In relation to this, petitioners referred to proviso to section 4(1) of the law, which states that where the offices or administrative units of the workplace are located at different places or divisional or subdivisional level, the internal committee shall be constituted at all administrative units or offices. They therefore said that when the office or administrative units are subdivided and are different, separate internal committees must be constituted at the level of such lowest or basic unit or office, and that a separate internal committee should be provided in junior college, which is a distinct workplace, while senior college should have its own internal committee in which no employee of junior college shall have any representation. Respondents, on the other hand, argued that the college at Nagpur is located in one compound and one of the respondents is principal of both senior and junior college. He is therefore competent to regulate functioning and discipline in both the colleges. Respondent also submitted that as employees of junior college and senior college share the same facilities and premises, in a hypothetical case, a senior college lady employee may complain of harassment by an employee of junior college and vice versa. And thus, constitution of one committee for such an establishment is in accordance with the provisions of section 4 of the law, as it is single or one workplace. Section 4 states that every employer of a workplace shall by an order in writing constitute a committee to be known as the Internal Complaints Committee. On the basis of the reasons pressed to show that the junior college and senior college constituted a single workplace, respondents contended that Srimati Brahmkar, a qualified teacher working in junior college, has been rightly nominated on the internal committee, as there has to be only one internal committee for senior and junior college. The question that were posed to the court therefore were: A. What is a workplace? Whether a senior college and junior college need to be treated as two distinct workplaces or as one workplace. And C. Whether constitution of one internal committee for both colleges is acceptable as per law. In this context, the court looked at the definition of workplace under section 2O and said that the definition is inclusive and has been deliberately kept wide by the Parliament to ensure that any area where women may be subjected to sexual harassment is not left unattended. It said that its clause 5, which states that workplace is also any place visited by the employee arising out of or during the course of employment, including transportation provided by the employer for undertaking such journey, shows even an artificial extension of workplace, and it may include workplace of other employer as well. It said that this wide canvas brings to the fore the intention to provide protection and prevention at all possible workplaces where either aggrieved woman works or may be visiting in connection with her duty, or the respondent is at work. Hence, any woman at her workplace cannot be disrespected by anybody. But similarly, she cannot also be disrespected when she is at workplace of the respondent. In this regard, court also referred to section 19 of the law, which deals with duties of employers and mandates that every employer has to provide a safe working environment for a woman at the workplace, which includes safety from third persons coming into contact with her at the workplace. With regards to the facts of the case specifically, the court noted that A. Standards 11th and 12th constitute a junior college, and students here are examined by the Maharashtra Higher Secondary and Secondary Board at the end of 12th class. B. Service conditions of teaching and non-teaching staff are regulated by Maharashtra Employees of Private Schools Conditions of Service Regulations Act 1977 and 1981. Rules are framed under it. And C. Students passing 12th standard may then take admission in senior college of same management or go to other colleges or streams. D. It is not necessary for the management to run both types of colleges. E. Service conditions of teaching and non-teaching staff in senior colleges are regulated by Maharashtra Universities Act and statutes or rules framed under it as per UGC guidelines. F. Recruitment processes to each of these colleges is different. In line with this, the court noted that junior and senior colleges form two distinct and independent establishments which have no functional integrality. Thus, even if very same management may run both these types of colleges, they can never be clubbed together. It said that ideally there need to be two internal committees for both these establishments. However, it went on to state that the problem arises when the state and students of both these establishments use same classrooms, same playground, library or laboratory and other common facilities like office room, waiting hall or common room or restrooms. The staff of otherwise distinct establishments must be frequently coming in contact with each other, and this may lead to frictions or problems like one dealt with in the law. A situation where a aggrieved woman is from junior college and the respondent is from a senior college or vice versa, therefore may also emerge. It is a workplace for all of them. It's said that when definition of workplace is scrutinized in this background, it does not contain a bar against providing a single internal committee for such a single or common workplace. It may at the most only desire a separate internal committee for distinct workplaces when the same are geographically separate or inconveniently located. The court went on to also observe that this obligation has been cast upon the employer for the convenience of the aggrieved woman. Common or one internal committee in a contingency is definitely helpful to all and also to smoothly deal with the allegation of sexual harassment at one go, avoiding the duplication and other related difficulties. It finally held that the constitution of one or common internal committee for a junior college and a senior college in this case is justified. With regards to presence of Srimati Brahmkar in the committee of the senior college, the court held that section 42C of the law itself contemplates association of one member from amongst non-governmental organizations or associations committed to the cause of women or a person familiar with the issues related to sexual harassment. Thus, when 3 of the total 4 members on the internal committee are validly nominated and in all its meetings there was quorum, it follows that merely because one of its member is from junior college, that by itself will not be enough to vitiate its proceedings. In our view, this part of the judgment is extremely valuable for employers that have multiple offices, whether in the same building, city, state or even across India. Especially with notifications being released by different districts regarding registration of internal committees, it often gets difficult to ascertain how these internal committees need to be structured and how many internal committees need to be constituted in each district for each branch and each office, etc. We hope that this judgment will lend some clarity to the confusion. If you found this information helpful, please like our video and subscribe to our channel for regular updates. In case you have any queries about the law or our services or want any assistance, please visit our official website www.poshatwork.com or contact us. All links and other details are provided in the description box below. Stay tuned for part 3.